Madam Ministers, thank you very much for coming in. Can we start with, you were both central, you were in the middle of stewarding this piece of legislation, this monumental piece of legislation through Parliament. The smoke is somewhat cleared a few days later. It's been almost a week now. It is law. Any reflections on the process itself, on what happened, on how you got this bill through Parliament? Ms. Wilson-Raybould.
Yeah, well, thanks for having us here, and certainly appreciate being here with my colleague, Minister Philpott. Some reflections on the process that we went through to get royal assent on C-14 medical assistance in dying. It was a difficult process. It was highly emotional. We engaged with so many Canadians right across the country, organizations, medical practitioners. And what we found and what we know to this day is that there's an incredible diversity of opinions out there around what type of regime we should have. And you know, we worked very hard to build consensus. That doesn't mean that everybody agrees on the approach that was taken in C-14, but we're confident in all of the discussions we've had with people across the country that this is the best approach for Canada right now and finds the necessary balance between personal autonomy and ensuring that we do our part to protect vulnerable people.
Minister Philpott, was there consensus? I mean, you had to observe cabinet solidarity. Was there a lot of discussion even before coming to your joint position as cabinet ministers? I mean, was there a lot of discussion among them, persuading your fellow cabinet colleagues?
Well, as my colleague has said, it of course was a real honor to be involved in helping to shepherd this piece of legislation through this process. It's a transformative piece of social policy change in this country. And the conversation started really for both of us from the minute the Prime Minister asked us to take our respective roles. It was something that both of us thought a great deal about. There had been a number of conversations. We looked, of course, to the excellent work that had been done by a number of bodies, including an external panel that weighed in on this, the work of the provinces and territories, and the work of the Special Joint Committee. Eventually, all of that came to our conversations in the Cabinet, where, again, we heard a diversity of perspectives on the issue. But I think Canadians would be very proud to know that the conversations were thoughtful, that we recognized the seriousness of the decisions we were making, and we did come to a very strong agreement that this is the right approach for Canada.
You've described, both of you described the approach as a balance between autonomy, individuals' autonomy, and a right to access to have help in medical assistance in dying, and vulnerability in protecting the vulnerable. You said that you got the right balance. But as you know, as the law now is in effect, there's still a lot of people who are worried about one aspect of it, and that is the concept written into the law of reasonably foreseeable death. And you've heard it, and we heard it even in the last hours of debate in the Senate. The concern is that that seems to close off people who are not at the very end of their life, people suffering grievous and irremediable pain, but who might not be in the terminal phase of their life. Can you address that? Because I know the senators gave you quite a grilling on that. Can you address that? Are you not closing off an avenue to a group of people who are recognized by the Supreme Court ruling?
Well, the senators did engage in incredibly thoughtful discussions, as did members of the House of Commons and at committees, and we very much appreciate that discussion. You know, talking about reasonable foreseeability, this is certainly a topic or words that are going to be continued to be discussed. We sought to, as you say, find that balance in a regime and for medical assistance in dying, and recognized that we need to do a lot more work and have a lot more engagement around what a broader regime, essentially non-terminal patients, what that would look like, how we would operationalize that if we were going to, and what necessary safeguards would have to be in place for patients that aren't approaching the end of their life.
But your briefing papers, and you told the Senate that a patient doesn't have to be terminal or in terminal phase. So which is it? I mean, is when people say, what does that mean, foreseeable, you know, reasonably foreseeable death, and does that mean I have to be within months? Is there a time frame that has to be put to my death?
Well, we sought, and of course, read the Carter decision from the Supreme Court of Canada very closely, and ensured that when we were drafting the legislation, we wanted to build in flexibility in terms of when a patient's death has become reasonably foreseeable. And we did that purposefully, in the sense not putting in a time frame like they have in other jurisdictions. In the United States, for example, they have a 6-month time frame, but we wanted to inject the flexibility for medical practitioners who have that direct relationship and expertise around their patient's care to be able to determine when their patient, having regard to all of the circumstances in terms of their grievous and irremediable condition, when their death has become reasonably foreseeable, and respond in kind to that patient.
Okay, so how does that work? Dr. Philpott, I mean, you are a medical doctor, family physician. How's that work then? If it's not like 6 months of a year from one's death, the terminal date has not been set. Both of you, I think, said Kay Carter would qualify under this legislation. Kay Carter's family is convinced that she wouldn't. The BC Civil Liberties Association is going to go to court over this. How do you determine what's reasonably foreseeable death? Who's eligible for this help?
Well, I think my colleague has already alluded to the fact that the clause around the fact that a person's natural death, it needs to be reasonably foreseeable, has to be seen in the context of all of the other eligibility criteria. And this is something that medical practitioners will need to take into consideration on a case-by-case basis. But there are a number of circumstances in a given individual where a particular diagnosis that in that individual, along with other comorbidities of other conditions, along with a person's frailty that comes sometimes with aging, need to all be taken into consideration to make sure that that person does in fact have grievous and irremediable suffering. But in fact, grievous and irremediable suffering alone is sometimes felt by medical practitioners not to be enough of a definition to help them to understand who should actually be eligible. And certainly from the practitioners that I talked to, and they were numerous, the understanding of the fact that a person's natural death is reasonably foreseeable really helps them to understand who might qualify. They would obviously need to document on what basis they believed that that was the case. And we have both said that in the case of the 2 people who were identified in the Carter decision, that we certainly have no doubt that they would have qualified under this eligibility
What
criteria.
if those 2 people in that decision were 10 years younger? I mean, Francis Lankin, for example, the senator and former health minister of Ontario, said this is ageism. What if you have those same grievous and irremediable pain and suffering, and it's without cease, and you're 60? And there's no foreseeable death from that medical condition. This is what people are still wrestling with.
Well, as I say, I don't think it's helpful to look at hypothetical situations, because every individual's medical condition needs to be taken in the context of that particular case. The other thing I think it's helpful to point out in this discussion is that I would agree with you that perhaps the loudest conversation was around the clause around the reasonable foreseeability of natural death. There were many other voices out there that we had to take into consideration. One of them were groups that represented people with disability, for instance, or Canadian Association for Community Living, who had very serious concerns about what implications there would be for the people that they represented if in fact there was a broad range of eligibility criteria. And in fact, as a physician, I can certainly say that while people may be suffering grievously, our responsibility, or the responsibility, I should say, of medical practitioners is to relieve suffering where at all possible, to protect people who are in vulnerable conditions, and that death should not necessarily be the very first option for people who are suffering.
One of the questions that comes up inevitably to the Justice Minister is, do you anticipate a legal challenge?
Well, I think there's the opportunity of legal challenges with any piece of legislation, and I certainly don't exclude this from that.
In terms of the inevitability, the probability of it?
Well, there's likely going to be challenges, and this is how laws develop. This is how our conversation that we've had in a substantive way among parliamentarians and Parliament's conversation with the courts in the development of C-14 is going to be important. I mean, we were asked by the Supreme Court, or they told us that medical assistance in dying is unconstitutional, blanket exclusion, and that they asked us to put in place the regime and provided great deference to Parliament to do so.
Did you consider a reference to the Supreme Court, sending it back? I mean, we had a lot of voices asking you to refer it to the Supreme Court.
Well, of course, I considered a reference to the Supreme Court.
Why not do that?
Well, I mean, we put out an explanatory paper that said and explained the circumstances that went into our considerations and our discussions around the legislation, and that included highlighting some of the charter risks. And I want to say clearly that just because there are charter risks does not render our piece of legislation unconstitutional. And so I go back to what the Supreme Court of Canada asked us to do. They asked us to do our job and put in place a medical assistance in dying regime in this country. And that's what all parliamentarians did in a very thoughtful way. And I feel that if we were to have asked for a reference to the Supreme Court, they probably would have said the exact same thing and asked us to do our job. And I think that the experience that we had with C-14 engaging with parliamentarians in such an in-depth way has resulted in a substantive piece of legislation that is going to direct this discussion for a long time to come.
So, Minister Philpott, where do doctors across the country go from here?
Well, I'm pleased to say that there's been a tremendous amount of work done at multiple levels. Obviously, our colleagues at the provincial and territorial level have done some necessary work to be able to provide guidance, as have regulatory bodies who regulate medical practitioners, physicians and nurses, for instance, have put out a very strong set of guidelines related to that. I know that my colleagues who are working in hospitals are working to establish a process that can be undertaken when patients request medical assistance in dying. So there's a lot of work to be done. We have work to be done on our own part to continue the further study that we have made commitments to. I have responsibility to put further regulatory measures in place. So we've taken a big step, and now there's more work to come.
And the criminal code now is changed, so that's a given.
That's right.
How did it feel your first 6 to 7 months of business being spent on this portfolio, on this subject?
Well, we've done this in the context of all kinds of other work as well, but this has certainly probably been the biggest piece that we have worked on. And as I say, it's been an honor to work on it. We have been tremendously supported by our Prime Minister, by our colleagues in Parliament, and by our Senator colleagues, by our fantastic staff members. So it's been a very positive experience, and we're very pleased to be able to help Canadians on this.
I think the idea, I mean, how we started the interview and talking about building consensus and hearing from diverse voices, even ones that don't speak as loudly as others, really came through. And the relationship that we developed with the Senate and how we're going to approach additional pieces of legislation into the future, I think, is defined by this really difficult piece of legislation that we all collectively worked so hard on.
Okay, well, I want to thank both of you for coming in, and we will watch with interest. I doubt there'll be any portfolios where you're working so closely, two ministers together, but thanks both of you for coming in.
Thank you very much.
Our pleasure.